for the second part of our Constitution Day celebration. I am very pleased to present our second speaker today, Mr. Robert McWhirter. Bob is a graduate of the Sandra Day O'Connor College of Law, one of the finest law schools in the nation. Upon graduation, he clerked for then Vice Chief Justice Stanley Feldman of the Arizona Supreme Court. He was then an assistant federal public defender, representing clients in a broad range of federal issues. At present, Mr. McWhirter is a senior attorney with the Maricopa Legal Defender's Office, defending death penalty and other serious felonies. He is a certified specialist in criminal law with the State Bar of Arizona. Bob has published several articles in the Georgetown Immigration Law Review and the Criminal Practice Law Report. And the ABA just published his latest book, The Criminal Lawyer's Guide to Immigration Law, Questions and Answers, as well as a very interesting publication called The Citizenship Flowchart. Both of these publications are back on the display case, back by the refreshments, so take a look at both of those. Bob is a popular and therefore frequent speaker, both around the Valley and abroad. This is the third in a series of multimedia talks he has presented about the history and development of several amendments from the Constitution, the Bill of Rights to be exact. His historical presentation on the Fourth Amendment, entitled Molasses and the Sticky Origins of the Fourth Amendment, has just recently been published in a summer issue of the Arizona Attorney, and a copy of that is also back with the other publications. The focus of his presentation today is the Sixth Amendment, and the talk is entitled, How the Constitution Guarantees You a Trial, a Lawyer, and a Chamber Pot. Please join me in welcoming Robert McWhirter.
Thank you. I should begin by saying I'm relatively well assured of good evaluations for this talk because my mother and my father and my uncle are here. So at least I have 3 in the bag. I also have to mention, just by happenstance, 2 of my high school teachers, including my high school history teacher, is here. So, you know, they were saying they're going to heckle, and I was kind of thinking of the fact that, you know, it wouldn't be any less than I deserve for some of the things I did. But, you know, no chewing gum and whatever. All right. How the Sixth Amendment guarantees you a trial and a chamber pot. Okay? Anybody want the definition of a chamber pot? Before you had flush toilets, I think we all know what we're talking about. All right. In 1649, John Lilburn needed to pee. John Lilburn kind of had a lot of problems in 1649. See, Cromwell, who was the Lord Protector of England, who succeeded after chopping off the head of Charles I, wanted him dead. Lilburn had just a big mouth. Okay, he is one of the reasons why we have a lot of the rights that we take for granted today. But because he had such a big mouth and was very influential and popular, he always caused problems for whatever government happened to be in power. First it was Charles I. After Charles gets toppled, Cromwell then becomes one of his nemesis. Okay, so Cromwell wants him dead, so he puts him on trial. 1649 trial in the Guildhall in London. That's City Hall in London. If you've ever visited London, you'll see the Guildhall. Okay, now this is where this man has his trial. It's a common law trial. That's important because what Parliament did was they had done away with Star Chamber and the Court of High Commission. So he had to be tried in a common law trial. We take it for granted that trials will be common law trials. Okay, it didn't used to be so. It's the common law trial and procedural system that won out. Okay, not only did John Lilburn need to pee, he needed a lot more. I earnestly entreat you that now you will please to give me a copy of my indictment. See, he didn't get the indictment before the trial. Or so much of it as you expect a plea from me upon, and an answer unto, and counsel assigned to me, and time to debate with my counsel, and subpoena for witnesses. See, Lilburn didn't get any of those rights. He didn't get a lawyer. He didn't get to subpoena witnesses. Didn't have compulsory process. None of those things that we take for granted. Now, he did, however, eventually get to pee. Sir, if you will be so cruel as not to give me leave to withdraw to ease and refresh my body, I pray you let me do it in court. Officer, I entreat you, help me to a chamber pot. Whilst it was fetching, Mr. Lilburn followeth his papers and books close, and when the pot came, he made water and gave it to the foreman. Now, if you look at the official trial record, this is recorded in that record, okay? I will just tell you that Lilburn did okay with the jury in this case, and I don't know how much this chamber pot incident had to do with it, but that may have been something. Lilburn did have one thing. He had a jury. Because remember I said the common law had won out. By definition, that meant you got a jury. About a couple decades after the Lilburn trial, William Blackstone wrote, "The trial by jury ever has been, and I trust ever will be, looked upon as the glory of English law." What Blackstone is reacting to is the inquisitorial methods that were going on in the continent at the time. Blackstone, of course, was very influential in America, and Thomas Jefferson, who had basically been a student of Blackstone, as were everybody else around, wrote in the Declaration of Independence, one of the reasons why we wanted to split from the king was for depriving us in many cases of the benefits of trial by jury. Works its way, of course, into the Bill of Rights, the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Again, these are all things we take for granted. Now, in the interests of time, I will be covering 3 parts of this. There's another version of this talk that covers the rest of it as well. We're going to talk about the history of the jury, where the jury came from. We're going to talk about then the assistance of counsel. Where did you get a defense lawyer? Okay, how did those grow up out of the tradition and system? And then number 3 I'll talk about is the confrontation clause. Confrontation clause in the Supreme Court's been in play since Crawford versus Washington, and that history comes out, okay? Just in other references, the Fifth Amendment has part of your jury rights as well. No person shall be held to answer for a capital or otherwise infamous crime unless upon a presentment or indictment by a grand jury. The Seventh Amendment gives you the right to a jury in civil cases if the amount in controversy be more than $20. The Constitution itself, in kind of a rarity, outlines the right to trial by jury. Trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed, but when not committed with any state, the trial shall be in such place or places that Congress may by law direct. The reason why that's remarkable is that the Constitution usually doesn't give you specifically rights. What the body of the Constitution tends to do is provide you the mechanism of government, okay? The Congress has these powers, the President has these powers, and the courts have, well, these powers, but of course the court can kind of expand and say what their powers are, all right? This is one of the rare instances where the Constitution itself provides the actual constitutional right. Okay, before we get to those 3 points of the Sixth Amendment, I wanted to talk a little bit about the accusatory trial tradition. Things didn't just grow up out of anywhere. In Europe, you had a sense, through most of European history, of open accusation. The cultural kind of norm, or at least the cultural symbol, of course, was the Last Judgment, which is a trial. And that's depicted here a little bit later in the Middle Ages period, but the same idea. You'll find this in art all through the Middle Ages. Okay, you have a judge. You have the court bailiff, who's usually St. Michael, okay? You get a halfway house, which is purgatory. The Department of Corrections, of course, is hell, okay? Let's do a little snapshot of this. Okay, here's the actual trial from the panel itself. Right here you have the chain gang. Everybody ever been in a criminal court? You have all these guys lined up, you know, they march in, okay? You have pretrial detention, okay? You have the defender, or the defendant rather, allocution, which is the right to say something before the judge imposes your sentence upon you, Okay, and then of course, there's no personal interest in this, but the angel is the public defender, in case anybody has any questions about that. Leaving, of course, the prosecutor also depicted in the scene. Okay, I have a personal friend who's a prosecutor in the Attorney General's office, and he objects to this, saying that those should be switched around. To which I respond, Randy, I'm sorry, I didn't do that. God did it. It's not my fault. All right. What this shows, though, is a model, which is kind of the notion of a trial somewhat akin to what we know today. All right? You go to China, they didn't have this idea. Okay, so what were the types of trials? There were three principal types of trials during the Middle Ages period: compurgation, ordeal, and combat, which is another type of ordeal. Okay? Purgatio canonica, purgatio vulgaris, and purgatio vulgaris. Okay, anybody here had Latin? Okay. Yeah, just be quiet, okay? I mean, my pronunciation of Latin is really bad. All right. All of this was based on the idea of purgation, which is where we get the English word to purge. Okay? A modern trial, you want to clear your good name. A trial in the Middle Ages, you wanted to clear your soul. The point was, if you could do that on earth, that's great. If you couldn't do it on earth, you got to go to purgatory, okay, where you could further purge yourself so you could be part of the Grateful Dead. Okay? I could burst out singing Truckin' right now, but okay, that's the idea. All right. So those were the three types of trials. Now, I'll mention, that's of course Mount Purgatory, which is an image from Dante's Inferno. I will mention trial by compurgation. It's actually part of what I deal with in another talk, which is the history of the Fifth Amendment, from testicles to dragnet, how the Fifth Amendment protects all of us. If you want more of that, you're going to have to actually come see that talk. But purgation was trial by oath. If you took the oath and you had 11 of your neighbors come in, they were compurgators. They were oath helpers, okay, or vouchers. With 11 oaths plus your oath, you couldn't be guilty because the oath was the proof. See, we use the oath today as part of the jury's evaluation of proof. Then the oath was the proof, okay, because nobody wanted to risk damnation. And, it was a public trial. If you could find 11 of your neighbors who you probably grew up knowing the same 50 people your whole life, you were probably innocent. Or if you weren't innocent, you were a nice enough guy that you should be innocent, okay? That's kind of how it worked. By the way, Rule 608, Federal Rule of Evidence 608, is still written today to allow only evidence of reputation or the character of truthfulness. This is a holdover from the old compurgation trials. Okay. Like I said, I talk about this a lot more in another context with the history of the right to remain silent. Okay? So I'm going to jump over that and go right to trial by ordeal. This is really misunderstood and maligned. You had a pretty good chance of winning in trial by ordeal. The thing to remember about trial by ordeal was it was about mercy. It was more about commutation than it was about guilt or innocence. And there's a lot of things going on in the procedure that kind of demonstrates that. God already knew whether you were guilty or not. What the ordeal gave you is the chance to get God's mercy. Ad judicium Dei, to the judgment of God, not judicium Dei, the judgment of God. He gave you a chance to get a break with the ordeal. Okay. For that reason, the kings didn't like it. Because you have this power struggle between church and state. A large part of the jurisdiction of England was actually controlled by the Catholic Church. The Norman kings accepted that in order to get the Pope to bless the Norman invasion, but they didn't like it. And over time, you have this power struggle that goes back and forth. William II. What is that? Is God a just judge? Damn whoever thinks it. He will answer for this by my good judgment, not by God's, which can be fooled this way and that as anybody wants it. See, he's objecting to the church using ordeals and the fact that so many people get off. Okay. One of the ordeals common in England was the ordeal of hot iron. This was for women, and there was a reason why it was for women. What happened, and let me just outline the procedure. The priest took the hot iron, he stuck it in the fire, let it sit there for a little while. Then he took it out of the fire and started a mass. He sprinkled holy water on it. Now, the amount of holy water was not specified. Okay, so if the priest likes you a lot, you're going to get more holy water on your hot iron. All right? The temperature wasn't specified. He laid the hot iron on a wood. Okay, obviously the iron's not hard enough to ignite the wood, and then the wood absorbs some of the heat as well. All right. The priest then reads the gospel. The length of the gospel is not specified, nor is the speed at which he is to read. More holy water goes on top of the iron at that point. Okay? The accused then grabs the iron, walks 9 paces. It doesn't say how fast you're supposed to walk, and drops it. The hand is bandaged. And after 3 days, a little jury comes and inspects the hand to see if it's healing properly. Okay? If it's healing properly, acquittal. You got God's mercy. All right? If it's not healing properly, well, you got a problem. Now, there's a lot of subjectivity all worked into the system. Oh, and don't forget the Lindenfrost effect. Because I knew you were sitting there thinking, well, obviously there's the Lindenfrost effect. Okay. Named after Johann Lindenfrost, who recognized the phenomena in 1756. The Fijian firewalkers probably benefit from this, and that is when you have a little bit of wetness on your hand, like if you're nervous because you're going to grab a piece of hot iron, it creates a buffer when the water molecules vaporize. You know when you have a really hot pan and you throw some water on it and the bubbles kind of just skips off? It's because the water molecules on the bottom vaporize, created a buffer, and it takes a few seconds for that water then to flatten out and vaporize. Okay? So you're actually protected. The Fijian firewalkers, who are a little bit nervous, walk rather quickly, and they're actually buffered and not burned because of the Lindenfrost effect. This same effect is going on at the same time with holy water and perspiration. Okay? So if you want to just have, ask the priest, could you bless my hands with a little holy water before I grab that thing? It's a good idea. Okay. So, what do you have with the ordeal? You get 4 chances. The iron caused no injury because it was allowed to cool. Only 2nd or 3rd degree burns, which don't show up as infected after 3 days. You need to have 4, 5, or 6 days. The infection would not have developed by the 3rd day for any other reason, or God spoke and worked a miracle. Okay? Ego te absolvo, which translates as, you beat the rap. Subtitle, why not? There's no need to be cynical about everything. So with those 4 chances, you've got a pretty good chance of trial by ordeal. Ordeal of cold water was reserved for men. Now there's a reason why the ordeal of cold water was reserved for men. The idea was you blessed the pond, you bound the guy up, okay? You put him in a tucked position, and you tossed him in the water to see if the water accepted him. If he sank, the holy water accepted him, and he was acquitted. They then pulled him out. Okay? Well, look, you can certainly game that system, right? You're fasting for 3 days before. You expel air, okay? Odds are you're going to sink in the tucked position. Modern studies have shown you got about a 95% chance of sinking if you're a guy. All right? Why not for women? The answer again is mercy. Women have a higher percentage of body fat, okay? A Rubenesque woman wouldn't have had a chance in the ordeal of cold water because they wouldn't sink, they float. Okay? You need the higher muscle mass to sink right to the bottom. So women didn't have to do that. That's why they had the ordeal of hot iron. Exception, of course, was for witches. The church and the kings changed the rule if you were accused of witchcraft, in which case women had to face the ordeal of cold water, which is why so many women got burned for being witches. All right. The ritual equals mercy. Okay, look, if you just want to decide, let's leave it up to God, you're going to flip a coin or throw the dice, right? But if you notice, in the entire process of the ordeal, there are all these ways to have subjectivity. All right. 70% success rate. From the available records that we have of these trials, there is a 68 to 70% success rate for the defendant. Okay, now I have practiced criminal defense for pretty close to 18 years. I would love to have a 70% success rate. All right. That's why the kings, this would happen to be Henry II, added you had to adjure the realm, which he banished people who passed the ordeal of hot water, or hot iron or cold water. And again, it's part of this church-state conflict, because the entire design is to be mercy, not to be more punitive. All right. Trial by battle. In the movies, you get Camelot, Excalibur, Might for Right. Anybody ever grow up reading King Arthur? Not my former high school teacher, Arthur Draper, not at all. All right. El Cid has a great scene where Charlton Heston plays the king's champion, has a big fight-out scene, kills Sophia Loren's father, which, they're in love, but that really pisses her off, okay, which is the premise of the movie. All right. Shakespeare, Richard II, Bolingbroke. They have a duel. The king at the end of the play kind of banishes him, so it's not a duel to the death, but it is part of the literature of trial by battle. Okay, trial by battle of combat was also called the wager of battle, or judicial duel. The wager was the promise that you made to the truth of your cause. Okay? Since the Norman conquest, Judicium Dei, God, judgment, it was another form of the ordeal. It was, however, reserved for the nobility, and usually the Norman nobility, because they're the only ones that could carry weapons. The wager is the oath of the witness or champion. Okay? When you put a chip down in a poker game and say, this is my wager, you're not saying this is my money. Otherwise, you just put down a dollar bill. The wager is a symbol of your promise. The old definition of the word is your promise. My wager is my promise to pay up if I lose. Okay? So all of this relates to the idea of the wager as the promise. Several origins are possible. They've traced it to Norman, Frankish, Scandinavian, Anglo-Saxon. The Scandinavians had the holmgang, which is you kind of threw like a skin on the ground or a carpet, and two guys walked up with shields and axes and just pounded the hell out of each other until somebody won. Okay? That was the early precursor. Okay? In the movie The 13th Warrior, there was an example of a holmgang, where they have a fight. I don't know if you saw that movie. Okay. Based roughly on Beowulf, by the way. In fact, some of the best lines in the movie are actually right out of Beowulf. The hero in the movie is Bolvein, okay, which is another way of saying Beowulf, Bolvein. Okay, often for undaunted courage, fate spares the man it is not already marked. Luck often enough will save a man if his courage holds. Okay? So really you've got it taken right out of Beowulf. All right? I thought that was cool, but it's kind of a guy thing, so all right. At any rate, biblical justifications for it are the story of David and Goliath. In medieval law, the Bible counts as precedent. So if you can find a biblical story to kind of make your foundation for your legal argument, you got a good argument. Okay? So they point to David and Goliath. Obviously, Judicium Dei, God wins out because puny little David, beats up on big Goliath. All right. Constantine, however, had prohibited gladiatorial combat, so the church was not all hot on this idea of trial by battle. It was also very expensive because your champion had to be a noble. Okay. The assize, which is a French word for session, okay, the assize of Clarendon in 1166 implemented trial by jury. They took an old kind of grand jury and they beefed it up and turned it into what we call the petit jury today. Henry II was part of that. It also brought in the role of squires. Okay. If you're a noble, you got a squire, right? And you want to send him, you're going to go fight it out with another noble because, you're arguing about a sheep or something, right? So you send your squire over there and they work out the details. Okay. no matter how boneheaded of a noble you are, you're going to figure out that there's a real advantage to trial by jury over trial by battle. And that is, if you lose, you don't get killed, right? So it became an advantage to have an esquire who had some legal knowledge that could find a technicality to get you into trial by jury. So the esquires who represented the principals became lawyers. And that's why lawyers use the term esquire as part of their name, because you're representing the principal who's really the one who's supposed to fight it out, and we're going to get you in trial by jury. All right. All right, the Fourth Lateran Council comes in 1215. No more ordeals, no more wage of battle. Okay? Innocent III. Big one in medieval history is Innocent III. So, that's out. And what we have replacing it is trial by jury, and the duel goes underground. Okay? Works its way into the Code Duello, which of course you have the Burr-Hamilton duel, is the most famous in American history. Weehawken, New Jersey, they rowed the boat over there, and then fate was sealed for both of them. A very good movie called The Duelists, which I would recommend to you with Carradine and Keitel, kind of lays out the entire procedure of the Code Duello. There are people that say it exists today and that it has legal validity going all the way back to the Middle Ages. Okay, now here's the question that I have to pose to you. We can sit back in kind of our perspective of the 21st century and say, oh man, isn't this primitive? Judicium Dei, okay, God thanks, we don't have to do this process anymore. We're much more rational. We decide things in a more scientific manner. All right. Isn't every Western you ever saw really Judicium Dei? Okay? High noon. Tombstone, justice is coming. Judicium Dei. It's the same premise. Courtroom. William Jennings Bryan, Inherit the Wind. Clarence Darrow. What lawyer doesn't see himself or want to see himself in that role of, might for right? Comes from Proverbs. He that troubleth his own house shall inherit the wind, and the fool shall be servant to the wise. Are we not beyond Judicium Dei? I'd say not. Trial by battle worked then, and it works now. Okay. A long, long time ago in a galaxy far, far away, I understand that's what the premise is, but it's the same idea. So I think this part of culture is still really deeply ingrained in all of us. Okay, the common law trial, courts and judges. Anglo-Saxon courts. This is Anglo-Saxon Britain. The judges were called witens. The courts were moots, the laws were dooms, and the counties were shires. The witens were the judges or ministers of men, counselors or wise men, okay? The witan was the king's council. It met in the Witanagamut, okay? From witten and from gamut, meaning meeting or assembly. That's where we get our modern word witness, for somebody who has knowledge, all right? Old English for knowledge, to know. We get the word wit, witty, witless, wit, snapper, witticism, wittingly, thus unwittingly, wit tooth, which is another word for your wisdom tooth, witmonger, wit wanton, who is somebody who uses wit wantonly, the movie Witness, and of course, witness for the prosecution. Okay? All of that comes back from the old Anglo-Saxon definition of somebody with wisdom or knowledge. Okay, the Witanagamut were, at one point they actually elected the Anglo-Saxon kings. Okay? It was based partly on inheritance, partly on election. The Norman kings kept the Witanagamut, which was an Anglo-Saxon institution, and rolled it into the Curia Regis. Okay? It becomes Parliament. The Curia Regis becomes Parliament. English House of Lords actually sits as the highest court of the king in Parliament, okay, which is the red-seated part of parliamentary government in England. Okay, Parliament sits as a high court, exercising that function that they inherited from the Witanagamut. So they're sitting like that. That then gives you impeachment powers. which leads, of course, to the impeachment trial powers of the Congress and Senate. It all traces back to the old Witens who could elect the king. Therefore, you can have the U.S. Senate, or the House, impeach Bill Clinton and the Senate have his trial. That is the origin of that power. Okay, modern references. Harry Potter. The wizards meet in the Wizengamot, okay, which is right there. Witana dooms. Dooms are laws, decrees, judgments, and accounting, okay, or a reckoning. The Doomsday Book was actually just a big accounting book that William the Conqueror sent his people out because he just conquered this place and he wanted to know how much it was worth so he could take as much out of it as he could get his hands on. Okay, so that's why it's called the Doomsday Book. Doom also has the sense of reckoning in terms of divine judgment, which is where we get our modern sense of the word. And of course, video games like Doom. Okay? You had the shires and the shire courts. Witens met in the shires as a local county court. It is where you get the shire moots, and then the shire is the Anglo-Saxon county. All right? So you have Buckinghamshire, Wiltshire, Hampshire, they all have that name. Or New Hampshire has incorporated that old Anglo-Saxon name. Okay? Shire, of course, is the place where all the hobbits live in Lord of the Rings. All right? The moots, these are examples of moot halls. By the way, the moot hall also doubled as the mead hall, so you could have court and then go to the bar and drink. Okay? That's what the moot was. Anglo-Saxon courts, mead hall, bar, the judges met in the moots. All right. The Ent moot in Lord of the Rings is where the Ents meet. Okay? So all the Ents hang out and they have an Ent moot. All right? And that is because Tolkien was an Old English scholar. He was a Beowulf scholar. Before he wrote Lord of the Rings, he did some of the groundbreaking studies of Beowulf. So he was an expert in Old English, and so he just grabbed that nomenclature and stuck it in Lord of the Rings. So that's why Ents meet in the Ent moot. All right. The Normans take over in 1066. Okay? The Bayeux Tapestry, Curia Regis replaces the Witanagamut. The King's Courts replace the Shire's Courts. The moots get mooted. All right? Moot then becomes a term of a court that starts to lose influence and jurisdiction. Eventually, the moots work into the Inns of Court, and the moots were then known as practice cases. So that's where you get the modern term moot court, because it was the old Anglo-Saxon courts that lost power and jurisdiction when the Normans took over from the Anglo-Saxons. Okay? So anybody who's doing moot court, that's where the origin of that comes from. Going courting, of course, comes from the Latin cohors, which is an enclosed farmyard where we get our modern word horticulture. The cohort was 1/10 of a legion, which would equal about 100 men, who was, commanded by a centurion. The Latin term courtum, and court is Old French, court is Anglo-Saxon. That's where we get the court plus the curia and our sense of a law court, as of an enclosed yard. Courting, such as in courtesy or courtesan or curtsy, all those words come from the Curia Regis, the same idea of an enclosed area. Okay, or Seven Brides for Seven Brothers, the song Going Courting. Okay, anybody clicking with me on this one here? Okay, good, all right. So that's not a guy thing, we had the other stuff. Okay. All right, common law trial. Now we get into the actual origin of the jury. This goes more for specifically that clause in the Sixth Amendment guaranteeing you your right to a jury. Okay, the jury, of course, is considered the community's conscience. All right? Okay. John Lilburn, in his trial, let's bring him back in here, played to the jury the entire time. The jury by law are not only judges of fact, but of law also. And you call yourself judges of the law are no more than Norman intruders, and indeed and in truth, if the jury pleases, are no more than ciphers to pronounce their verdict. Now you can well imagine that the judges kind of got pissed off at Lilburn for this one. What he's arguing is what? Jury nullification. Okay? He's also doing something clever. He's talking about this concept of the ancient constitution, this pre-Norman constitution, creating this mythology that in Anglo-Saxon times everybody was in this kind of happy democratic state. Okay? Thomas Jefferson picks up on the same thing. Jefferson and others adopted this theory. Okay? Remember all that stuff you learned in high school social studies and history about, we have these inherent rights as Englishmen, and the king's denying us those. What they're saying is we have these inherent rights as Anglo-Saxons. See, the king is a Norman. He's trying to take away our inherent Anglo-Saxon rights. Now, the historical record doesn't exactly support this interpretation, but this is exactly what Jefferson and these people were talking about. Okay? We're touching into the ancient constitution in front of these crummy Normans that took over. Now, of course, George was no more Norman than anybody else who was a Hanoverian, but that was the idea. Okay. So then you get the origins of the jury. Socrates, by the way, in his trial, 399 BC, had a jury of 500 Athenian citizens. The Athenians had big juries because they figured it would prevent bribery. Because, you might be able to bribe 12, but bribing 500 would be kind of hard. Okay? They convicted him 208 to 220. They then voted for death by a vote of 360 to 141. In large part, in all likelihood, because Socrates handled his own mitigation and arguing that not only should he not be put to death, but the public should pay him free meals because he was such a good philosopher. That kind of pissed the remaining holdouts off, and so the margin for death was much bigger than the margin for guilt. Okay. Underscoring that the American Bar Association standards on death penalty trial defense requiring at least 2 lawyers, one to focus on mitigation, has a good historical precedential reason. All right. But of course, Socrates does get to become part of Bill and Ted's Excellent Adventure and one of the characters in that movie. Okay. Romans had juries. Early in the Republican period, early empire, they ranged from 32 to 360. Usually they're around 75. There started to develop the vicine, okay, your local vicinity people. The judges would call these people in to give advice on local custom and law when making the decisions. Okay, so the jury's source then, there's Frankish origins, English, Scandinavian, Anglo-Saxon, Norman, all of them, okay? The scholarship on this area is kind of all over the place. Thomas Jefferson said the juries went from England to Normandy. Probably in all likelihood they went the other way. That probably it was a Norman invention because there's precursors under the Dukes of Normandy for jury practice. So in all likelihood they brought it the other way with them. Okay, why 12? Like in 12 Angry Men. Well, you've got, of course, 12 apostles, 12 tribes of Israel. The Anglo-Saxons and the Danes had their 12 thanes, okay, who were kind of big guys in the community who decided things. They formed an early type of grand jury. Compurgation, remember we talked about that, required your oath and 11 oath helpers, making 12 oaths. Okay? That seems to be the most likely origin, and going back, they had 12 because, of course, 12 apostles in the 12 tribes of Israel. Okay? 12 is a native English word from the Germanic tu lif, which means 2 left over after you take away 10. Okay, that's where the name comes from. 12 is the last number before the formula 13 and 14. 12 has its own name, which is a dozen. There is cheaper by the dozen, 2 versions, the dirty dozen. Let's see, 12 signs of the zodiac, including the Chinese zodiac. There are 12 months in a year, 12 inches in a foot, 12 hours on a clock, 12 days of Christmas. 12 by 12 is a gross. 12 is a lucky, is between lucky 11 and unlucky 13. And then there's the 12 Olympian gods. Okay. When you want to mess with my 12-person jury, I would just suggest that you don't do it. Okay? Because there's a lot of good precedent that says don't do it. The early jury, they were not passive note takers. They were there to be witnesses. They were there to tell you what happened, not just decide it after the fact. Okay? The jurors were the witnesses. The title juror, okay, comes from the Latin jurata, which is the oath that the jurors took. The oath takers were juratores. That's where we get our modern word jury or juror. So they got their name because they took an oath to tell the truth. The verdict that they gave came from the Latin vere dictum, to tell the truth, as in the English word verify, and dictum as in the English word dictate. So they were brought there to swear an oath, to tell the truth, to tell you what happened. Because you know what? They knew everybody. They knew that that goat belonged to Joe. Okay? They probably also knew what Joe was doing with the goat. Okay? They knew all that stuff. We choose them now because of what they don't know. Then they chose them because of what they did know. They were self-informed. They came from your village. They were expected to know the parties. Okay? So you didn't have this same concept of 12 angry men where everyone gets together and doesn't know anybody. Okay. If you look at the wording of the Sixth Amendment, an impartial jury of the state and district wherein the crime shall have been committed, it's really an historic anachronism. Because it really goes back, and it was anachronistic when it was written, it goes back to the notion that the jury was informed, not ignorant of the facts. That's why they had to come from your state and district. Okay, so they sent you to the ordeal, which would be today commutation. The indictment is what they found in a later period. It comes from the Latin indicare, meaning to point a finger at, which is the English to indicate. The Norman inquest was kind of an invention that took over this jury system in order to create more criminal prosecutions. Okay? So Henry Fonda, when he walks in with the switchblade and 12 Angry Men's and kind of pounds it on the desk, okay, what do we call that today? Juror misconduct. Okay? Because you're not supposed to bring in evidence that wasn't admitted into trial in the deliberations, right? Back then, that is exactly what he was expected to do. Okay, the Assize of Clarendon, 1166, you created presentment juries, okay? And why were they presented? They presented the case up. When an official brought the case, it was an indictment, okay? So let me explain that. The grand jury goes out and investigates the case, and the grand jury brings it, okay? They then present it to the king. If a king's official goes out and presents the case to the grand jury, then they indict, they indicate. And that's where you get the two terminology, okay? Sixth Amendment, no person shall be held to answer for a capital or otherwise infamous crimes unless upon a presentment or indictment of a grand jury. That's why you have the two terminology being used. And again, it's by the time the Constitution was written, it was really historically anachronism, okay? All right. You had the bulla vera, or the bulla ignoramus, okay, which is an order of true bill or ignorant of the evidence, okay? Henry II started to fine grand juries when they didn't bring enough cases, okay? You ever know why they call the term indictment as handed up? Because it never made sense, because you got a grand jury who hands it up, and a petit jury, the smaller jury, decides. Well, it's called handing up because it was handed up to the king, okay? And we still refer to an indictment being handed up for that reason. Okay, what's Henry's motive? Tough on crime versus show me the money. The king gets the chattels. The king on the death gets a big death tax, but if you're killed by somebody else, he gets everything that that guy had, okay? He gets the chattels, all his movable property, okay? It means movable property, private movable property, as opposed to real property, which is land, okay? Quadruped livestock, sheep, goats, swine, herds, mules, and asses. Today, we say cattle and use it to refer to bovines, okay? It comes from the chattel for movable property, which means your goats and everything, but now we say it's cattle, all right? So, how did he get the money? He sends a tax collector to the shires, whose name is the Shire Garif, The French word is shire rev, for shire revenue, which we call the sheriff. He was the king's guy who went out and got those taxes, like in the Sheriff of Nottingham in Robin Hood. Okay? So you get this modern sheriff in Western movies who's the good guy, but in all the Robin Hood movies, the Sheriff of Nottingham is the bad guy because he's squeezing the dough from the poor. Okay, so that's his job, is order to make the king's coffers work. Okay? I have 3 small children, so I've seen the Disney version more times than I care to count. All right, crime never pays. We need to head them off at the pass with a posse. I think people locally here know about Sheriff Joe. Okay, the posse is an old term, comes from posse comitatus, which is the power of the county. The king could, or the sheriff could, seek the hue and cry, create a posse, and that was your early local police force. Okay, and of course Joe still has the posse today. All right, the constable was not law enforcement. See, he was the keeper of the castle. All right, which is constable of the tower, like in the Tower of London. It comes from 2 Latin words, comus stambuli, which is attendant of the stables. He was the stable boy, okay, who over time started to gain more power in the king's favor because the king liked his horses. All right, it's where we get the modern term cops, which is short for constable on patrol. Okay, then of course you get the English version, which are, I think I do this, which are called bobbies, after Robert Peel or Peelers were the first modern police force. Okay. He also got the money in another way. He had a crown official, okay, who was the keeper of the pleas of the crown, who was the crowner or coronator, or the coroner, as in our word coronation, or of course the beer Corona. Okay. See, he would work with the inquisito, which can be translated in 2 ways in English, the inquest or inquisition. Of course, English has the more pejorative reference as inquisition, but we also use the term inquest, which is the coroner's court, which we still have in jurisdictions today. Okay? So that's where you get the term the coroner's inquest, because the coroner looked at dead people to see if the king got his share. Only later did he get the role of saying how the person died. Okay, which is the modern role we understand it, and then of course now we use medical examiners. Okay, king's officials are not popular. Okay, you've got Basil Rathbone fighting it out with Errol Flynn. Okay, Rathbone actually was a much more accomplished fencer than Errol Flynn. Flynn would have actually lost to Rathbone, and you can see this. Flynn actually lunges poorly, which Rathbone parries with a parry 4. Okay, so that kind of just shows that Rathbone would have kicked his butt, but Errol Flynn was the hero of the movie. All right. At this point, you start to develop a split between the grand and the petit juries. All right? Because remember, we've gotten rid of ordeals. So after the jury decides that you're going to face a trial, in other words, they think you're guilty already, you have to have something to replace it. And so they come up with this idea of the petit jury, Fourth Lateran Council, no more ordeals. Presentment juries had no place to send. So the answer, Europe goes inquisitorial in their procedure, goes to a judge who makes a further determination. England develops the petit jury, a smaller part of the grand jury. Magna Carta of 1215, the same year as the Fourth Lateran Council. No freeman shall be taken or imprisoned or desist or exiled or in any way destroyed, nor will we go upon him nor send upon him except by lawful judgment of his peers or by the law of the land. So you've got Magna Carta starting to incorporate this clear right into English law and the common law. Petit comes from the French word for small. Vox populi replaces basically vox Dei, the voice of the people rather than the voice of God for deciding what's going to happen to you. Okay, Magna Carta of 1215. This is a depiction of it. Okay, King John was a wimp. Okay? Basically, his father created this huge empire, which John succeeded in getting his butt kicked all over the place. And Sans Terre was his nickname, which in English was Lackland. He lost it all, pretty much with the exception of England. Mother always liked Richard best. The movie Robin Hood has that king. Okay, that was John. Okay? What he's referring to, by the way, is his brother Richard the Lionheart, who plays in movies as kind of a tough guy, right? Okay, John gets the kingdom after Richard dies, and he kind of has this massive inferiority complex, which if you understand, see, his parents were Henry II and Eleanor of Aquitaine. In the movie Lion in Winter, you've got Peter O'Toole and Katharine Hepburn sparring this whole time, and John's just kind of running around. So this guy has a major inferiority complex, and so that's what gives us Magna Carta, okay? So because John has an inferiority complex, we start English common law. Okay. The grand jury kind of gets named in the reign of Edward III, okay? Gets institutionalized in the 14th century, the number's set at 24, Le Grande Inquest, all right? Just for your information, that's Edward III and his son, Edward the Black Prince. Edward's mom was Isabella, who is known as the She-Wolf of France, who just so happens to be played by Sophie Marceau in the movie Braveheart. Now, the interesting thing about historical accounts is usually the Hollywood actors are a lot better looking than the people really were, okay? In this instance, it appears not to be so, okay? All accounts are that Isabella was as good looking as Sophie Marceau, okay? At any rate, Edward the Black Prince is the prince in the movie The Knight's Tale. So that's how that loops around back there. All right, Blackstone's commentaries again. The common law wisely placed this strong and twofold barrier of a presentment and a trial by jury between the liberties of the people and the prerogative of the crown. Okay? True at the time of the American Revolution versus history and current practice. If you recall, the grand jury was really designed to get the king more money. It wasn't designed to be a protector of your liberties. Today, I think you'd really have to question how much the grand jury helps out. And I have prosecutor friends who swear that the grand jury really is a great barrier to bad prosecutions. You know, I have yet to really be convinced of that. At the time of the American Revolution, though, American grand juries were regularly not indicting people for offenses against the crown. So the grand jury did serve that purpose at the time of the writing of the Constitution. All right, history of the Confrontation Clause. That is Sir Walter Raleigh. We'll talk about him more in a second. Back to John Lilburn. Produce them in the face of the open court, that we may see what they accuse me of, and I am ready here to answer for myself. So Lilburn is asking for a confrontation clause. He looks to history to get this. Now, I'll tell you, Lilburn didn't get it. Sixth Amendment in history. Here's what the defendant has a right to be confronted with the witnesses against him. If you look at Crawford versus Washington, it goes into this history a great deal in order to justify what Scalia wanted to do in 2004. The Romans required viva voce, live voice testimony. So they required confrontation. The Catholic Church under the Gregory the Great incorporated that as the standard under canon law. Okay, so ecclesiastical law required that as well. The Apology of Socrates, written by Plato. And the hardest of all, I do not know and cannot tell the names of my accusers, for I cannot have them up here and cross-examine them. And therefore I must fight with shadows in my own defense. That is a great image. That's an image that I plan to use in a trial at some point. Okay? He's shadow boxing in his own defense when you don't have the witnesses there against you. The biblical precedent in the jus commune in Europe and the canon law was the woman taken in adultery, no accuser or confrontation, hath no man condemned thee, neither do I condemn thee, go and sin no more. There's no one there to make an accusation, no confrontation clause that's been satisfied. St. Paul and Governor Festus. Is it not the manner of the Romans to have the accusers before him? See, St. Paul was in hot water. He demands, since he was a Roman citizen, to be tried in a Roman court. So therefore he's taken and he gets Roman procedure, which requires confrontation. Okay, now Festus, of course, was, the sidekick in Gunsmoke, okay? That's where the name comes from. It's Governor Festus, who was in the Acts of the Apostles. All right. Shakespeare in Confrontation talks about it. Again, Richard II, then call them to our presence face to face, and furring brow to brow ourselves, we will hear the accuser and the accused speak freely. So in Shakespeare's time, again, you have this sense that fair procedure demands confrontation. Okay, the generation before Lilburn, Sir Walter Raleigh and the Confrontation Clause, okay? He was the one who laid his coat down before Queen Elizabeth in the mud, okay, which I think is one of the great acts of suck-up of all history, all right? So she becomes one of his favorites, and you have several Hollywood movies, including The Virgin Queen and The Golden Age, Elizabeth the Golden Age, which is the successor to Elizabeth, which is both movies I'd recommend to you, kind of depicts Sir Walter Raleigh. Clive Owen plays him in this movie. Okay, Virginia then is named for Elizabeth because she's the Virgin Queen. Okay? Now, nobody really knows whether she never had sex in her life. The point is she never took a husband, which meant that she could rule as the Queen Regent instead of the Queen Consort, Regina Regent instead of Regina Consort, which meant she kept power. If she would have married, the man would have gotten the power. So that's why she stayed unmarried her entire life, because she ruled. Okay, 1603, she's out, and her little kind of pukey nephew, who's James I, comes in. James I was the son of Mary Queen of Scots, who Elizabeth had beheaded. Okay? You want to talk about a dysfunctional family? Okay, this is where you're getting it. All right. He takes over after Elizabeth dies childless, and he doesn't like Walter Raleigh at all. And Raleigh gets put under treason trial in 1603. Cobham is supposed to be part of this conspiracy to kill King James. He implicates Raleigh, and so that's what starts the trial. Raleigh says he wants to confront his accuser. Cobham is absolutely in the king's mercy. To excuse me cannot avail him. By accusing me, he may hope for favor. The proof of the common law is by witnesses and jury. Let Cobham be here, let him speak it, call my accuser before my face. See, he's calling up the common law. There are still these other courts sitting around that James wants to use, the king, right? But he's calling on his common law rights. This stuff has started to be incorporated into the common law. So he has a trial. The prosecutor is Attorney General Cook. Okay? Actually, it's Coke, but it's spelled Cook, but you say it's Coke. Okay? Great scholar, great champion of the common law. However, in this trial, he was totally kind of a lackey of James, because his job was to get Raleigh. Thou art the most vile and execrable traitor that ever lived. You speak indiscreetly, barbarously, and uncivilly. I want words sufficient to express thy viperous treason. I think you want words indeed, for you have spoken one thing half a dozen times. Thou art an odious fellow, thy name is hateful to all the realm of England for thy pride. It will go near to prove a measuring cast between you and me, Mr. Attorney. Okay, now this is all on the court record. Okay, and this is the way this trial was going back and forth. The trial ends with this little piece of theater. Okay? I have plucked from my pocket but another letter from Cobham. Nothing but the truth, the whole truth before God and his angels. Raleigh is guilty. All right. Raleigh jumps up at that point and says, not so fast. I have another letter from Cobham too. I never practiced with Spain by your procurement. You are a true subject, as I know no treason by you. Okay, so they're playing with these out-of-court declarations back and forth, kind of angling for political theater. All right. Result was Raleigh gets convicted. He's actually executed 15 years later. He lives for 15 years under a death sentence, which he's supposed to then behave and do things for King James. And finally, James gets pissed off at him and decides to have him executed in 1618. He smokes a pipe. James hated tobacco, okay? Hated it. He actually wrote a little treatise against tobacco. Raleigh, of course, is credited for bringing tobacco to Europe and making Jamestown, a profitable colony because of the planting of tobacco, cultivation of tobacco, okay? So Raleigh, of course, when he's going up to the gallows, is smoking a pipe, just to kind of piss James off one last time. This is sharp medicine, but is a physician for all diseases, okay? Raleigh's trial judge laments, the justice of England has never been so degraded and injured as by the condemnation of Sir Walter Raleigh. Okay, all this leaves a very bad taste in people's mouths. All right, what happens? About 100 years later, George Mason is writing the Virginia Declaration of Rights, 1776, which a lot of the Bill of Rights is based on. And he writes it in Raleigh's Tavern in Williamsburg, Virginia. And that is where the first confrontation clause in any constitution was written down. That, of course, becomes that part of the Sixth Amendment that guarantees you a confrontation clause right. And it's all based on this history of Sir Walter Raleigh and the reaction to it. This is the history that the Supreme Court invokes when it produced the Crawford decision. Okay, what time we got here? Just a little bit. Lilburn still needs a lawyer. In 1649, I earnestly entreat you to give me counsel assigned me and time to debate with my counsel. My prosecutors have had time enough to consult with counsel of all sorts and all kinds to destroy me. Hear me one word and you shall have two. Your life is by law as dear as ours, and your souls are at stake, and our souls are at stake if we do you any wrong. If you will not allow me counsel, I have no more to say to you. You may murder me if you please. Okay, and that wasn't really true because Lilburn always had a lot more to say. But see, here we've got an idea in the law at the time was that the judge was supposed to be your defense counsel. He was supposed to tell you about the law and kind of help you along. You were supposed to provide the facts, but the judge was supposed to protect you. Again, Cook's institutes, first, that the testimonies and the proofs of the defense ought to be so clear and manifest as that there be no defense to it. Secondly, the court ought to be instead of counsel for the prisoner to see that nothing be urged against him contrary to law and right. All right, what's the problem with this? Well, you know, Lilburn's judges had a job. They were supposed to get him killed. Okay, it was a state trial, treason. The defense court of counsel stuff just didn't work in that context. I hope the jury hath seen the evidence so plain and so fully that it doth confirm to them to do their duty, dirty duty, and find the prisoner guilty. Okay, this is Lilburn's judges. Now you gotta, wonder why he didn't want these people to be his counsel. Okay, they were trying to kill him. All right. Shortly after his trial, the Treason Act of 1696 gets passed. Guarantees the right to counsel in treason trials. The reason is treason laws are complicated. The judges were against the defendant, and the Crown had prosecutors. Okay, it's about 50 years too late for Lilburn, but this is what first comes in as the first right to counsel in the common law. Trial for the Norman guy, Thomas Smith, described it in Elizabeth's time as an altercation, the judge and the witnesses versus the defendants. Okay, this has been called the accused speak trial, and there's some indication that it continued on well into the early 1800s in England, with no defense counsel being present. Okay. What changes things? Prosecutors start to come in. The Crown starts to see that there's an advantage to prosecution. Okay, now in Norman times, all prosecution was private. We study tort law and criminal law. Back then, there was just tort law. You didn't have criminal law. Everything was done in the courts by private individuals. There was the weregild. Were is Old English for man, okay? As in the term werewolf, guild, okay? Is the root Germanic for payment. It's the gilt, which is the Dutch and German Yiddish word for money, okay? So it was the man price. Your family would pay that off so that you wouldn't have retribution on your family. The term murdrum was the fine that a Anglo-Saxon would pay to the Normans when a Norman got killed, but it would be the entire village. And what the Normans started to do was any dead body was assumed to be a Norman until it was proved to be an Anglo-Saxon, which meant your local town had to pay this murdrum, which was the fine. So what started to happen a lot was anytime there'd be a dead body that nobody knew who it belonged to, they would wheel it over to the village next to you and dump it there because nobody wanted to have to pay this fine. And then this is where we get our modern word murder from. Okay, the judges were the law enforcement. You didn't have police. It was the king's judges that went out to enforce the law. Okay, the traveling justices, okay? Supreme Court justice, okay, justicier, that's where we get our modern term justice, as in the justice of the Supreme Court, okay? With self-informed juries, you really didn't need a prosecutor. The jurors came in and kind of fulfilled that function. They were the witnesses, prosecutors. The judge just kind of presided over criminal justice. Okay, the king's peace. Eventually, you had developing this office of justices of the peace. They were the keepers of the king's peace. They made bail decisions as of Queen Mary. Okay, the Marian detention statutes get their origins for this. These justices of the peace start to do investigations of the case to prepare the case for the traveling judge, so they're the first prosecutors in a sense. When we refer to a justice of the peace today, it's supposed to be a judicial officer. At this period, they were a police officer. Okay, they come to America, the Old West. You've got Judge Roy Bean, the saloon keeper. Okay, law west of the Pecos and ice cold beer were the two signs that he had in his bar. He held court as justice of the peace in his saloon. Okay, life and times of Judge Roy Bean, the Westerner, Gary Cooper. Okay, that's all the image that we still have in the United States. All right. Social change starts to come to England in the 18th and 19th centuries. Population growth, urbanization, interests of the crown go beyond treason trials. They start to hire professional prosecutors. Different parts of the English government do that. Okay, and this is where you get the growth of the first police officers, the bobbies or the peelers, named after Robert Peel. Okay, so judges now start to leave this role as police officers because you have the beginnings of real adversarial proceedings as we know it. Prosecutors then start to be part of a change in the standard of proof. And this is where you get the rise of the reasonable doubt standard. In 1649, one of the few things Lilburn could count on was the standard of proof. Here's the argument that the prosecutor makes in his case. You have heard the several charges proved unto you. For my part, I think it is clear as noonday. Prosecutors had proved their case clear as the noonday. Another way of articulating that was beyond any doubt. Okay? In medieval times, it was the oath and ordeal that were greater than reason. The oath was the evidence. So you didn't have to have a reasonable trial in that sense. And the Crown and Roman law, the standard was proof beyond any doubt, not proof beyond a reasonable doubt. So the prosecutors had to reach a really high standard to get somebody convicted. Okay? So here's what you had. Here was what the balance was. The defendant didn't get a lawyer, no indictment, no subpoenas, no continuances. On the other hand, the prosecutor had to prove the case beyond any doubt. That was the balance in the system. The testimonies and the proofs of the offense ought to be so clear and manifest as there can be no defense of it. Okay, now that's a very high standard that we don't have today. Okay, what happens? Reason starts to come into the law. The 17th century is the age of reason, the first part of the age of enlightenment. You've got the scientific revolution, irrational proofs get rejected, you get a return to classical teaching. What you have in England is basically jumping over the Middle Ages and the entire legal structures that existed there back to classical thought. Aristotle. It is evidently equally foolish to accept probable reasoning from a mathematician and to demand from a rhetorician scientific proof. See, us rhetoricians now, according to Aristotle, don't need to prove things beyond any doubt. Okay? Probable reasoning is allowed for a rhetorician, i.e. a lawyer. Not absolute proof, not proof beyond a reasonable doubt. Locke takes this idea and in his essay concerning human understanding starts to present this idea as the basis for human rationality. Geoffrey Gilbert picks this up in the first evidentiary treatise from the period, okay? A treatise on evidence. He abstracts Locke as the first part, and then he tries to connect this with a decision-making process. Okay? It's a methodology that comes in. The trial now becomes a closed Newtonian universe. You know, Newton's going on at this time too, all right? Human reason is what you need to discern God's clockwork and find the truth. Now, a lot of this is based on anti-Catholicism, okay? This irrational papist stuff, okay? We're going to react to that, and we're bringing in this rational method, okay? No self-informed juries and no judicium Dei. Those go out. And we're going to have juries that we want to be relatively ignorant, and we want to offer them the evidence within this narrow universe that we create called the trial, and within that we're supposed to find proof. Okay. Both occur in the mid-1750s. The Crown starts to have more prosecutors. Defendants start having lawyers in response. Because if you give the Crown the right to have a lawyer, then you have to give the defendant a right to have a lawyer. New rights begin to emerge, okay? The Sixth Amendment is the first one that really lists those rights down, okay? Now, the great example of this, at least the first example, where this argument kind of plays out was actually the Boston Massacre trial of the 1770s, okay? The prosecutors were asking for a reasonable doubt standard. John Adams wanted the any doubt standard. Okay, you remember the Boston Massacre, five people were killed, okay, March 5th, 1770. I was horrified when my high school history teacher up there mentioned that, you know, those little snowballs that the Patriots were throwing at the soldiers had rocks in them, okay? It depends on whose version of the fact of what went on here. At any rate, these guys get put up to trial. There's the trial bill. Captain Thomas Preston was the leader, and 8 soldiers were all put on trial. Okay, here's what happens in the trial. John Adams was for the defense, along with Josiah Quincy Jr. For the prosecution or the Crown were Thomas Treat Paine and Samuel Quincy. Okay, you got Quincy's on both sides of this case. All right, they were actually brothers. Samuel Quincy stayed a loyalist, left after the Revolution, never to see America again, and his brother, of course, stayed here. Thomas Treat Paine was another signer of the Declaration of Independence. All right, closing argument for Adams. The best rule in doubtful cases is to acquit, then convict. And where you are doubtful, never act. If you doubt of the prisoner's guilt, never declare him guilty. Okay, that's the beyond any doubt standard. Closing argument for Paine. First of all, he talks about, basically, this is a Newtonian term. Our law in general is that ultima ratio, the last improvement of reason, which in nature it will not admit any proposition to be true of which has not evidence. Okay, he's trying to create this closed universe, right? If, therefore, in the examination of this cause, the evidence is not sufficient to convince you beyond a reasonable doubt of the guilt of all, you will acquit them. Okay? But if the evidence be sufficient to convince you of their guilt beyond a reasonable doubt, the justice of the law will require you to declare them guilty. See, he's arguing for the modern standard, the beyond a reasonable doubt standard. Okay, what happens? The judges gave the any doubt instruction, which is what Adams had asked for, and for that reason, Adams won. 2 soldiers got convicted of manslaughter. They received a branding of an M on their hand. That was it. The aftermath was that America adopted the reasonable doubt standard. See, this verdict was very unpopular at the time. So that's when this country brings in the any doubt standard and norm to America. Okay. Now here's the new formula. The prosecutor will win with the new formula, but here it is. Prosecutor can go reasonable doubt. Okay? Coke is out, Locke is in. But then we also have the 6th and 5th Amendments now. You get a lawyer, an indictment, subpoena, continuances, confrontation, open trial, and a jury. See, this is the new balance. The prosecutor has a lower standard, but the defendant can defend. So the trial is a much more adversarial thing than it was before. The Lilburn's legacy. Lilburn plays to the jury. The jury by law are not only judges of fact, but of law also, and you call yourself judges of the law are no more but Norman intruders, and indeed and in truth, if the jury pleases, are no more but ciphers to pronounce their verdict. Was there ever such damnable blasphemous heresy as this is to call the judges of the law ciphers? Okay, they didn't like that. Sir, I entreat you, give me leave to read the words of the law, then for the jury I apply as my judges, both in the law and the fact. Judge, of course, takes the bait. That the jury are the judges of the law, which is enough to destroy all the law in the land. There was never such damnably heresy broached in this nation before. I realize the jury's hearing all this. Okay, what happens? Lilburn gets acquitted in less than 2 hours. The verdict was met with a loud and unanimous shout, which lasted for about half an hour without intermission. I kind of have a feeling that Lilburn had stacked the jury with his own supporters. Okay, something was going on there on the other side. Cromwell was infinitely enraged and perplexed. Lilburn's acquittal is a greater defeat than the loss of a battle would have been. So he didn't like that at all. Now, Lilburn dies in 1657. But his legacy really is the Sixth Amendment. Hugo Black was a great admirer of Lilburn. He wrote an article, or the article, Encyclopedia Britannica, about the history of John Lilburn. You will find in many of Black's opinions references to the Lilburn trials, both of 1637 and 1648. So what we have here then is the Sixth Amendment, and that is John Lilburn's legacy. So. Are there any questions? We have 5 minutes.